But the year going for conference.
So shall we start?
Yes, yes.
So behind every patent is a dreamer. Behind every trademark is a story. And behind every copyright is a creator. We wish you all a very warm good morning. On behalf of Amity Law School, Amity University, Madhya Pradesh, Gwalior, it is our absolute pleasure to welcome you all to this 2 days workshop titled Rhythm of Rights, workshop on protecting musical works in the evolving intellectual property landscape, organized in celebration of World Intellectual Property Day. Every year on April 26th, World IP Day brings attention to the role of intellectual property plays in encouraging innovation and creativity. This year, we are tuning into a unique harmony, the one that exists between the law and the music. We have two esteemed speakers who will help us navigate the evolving soundscape of IP rights with the insight and expertise. So, whether you are a law student, an artist, a researcher, or just someone who enjoys a good beat, this workshop promises to give you a deeper appreciation for the invisible yet powerful legal frameworks that keep the rhythm of rights alive. Once again, a warm welcome to each of you. Let's make this workshop not only informative but also inspiring.
With this, I take a moment to introduce Major General Rajendra Kumar, Ati Vishesh Seva Medal, Sena Medal, Vishesh Seva Medal, an alumni of ILS College, Pune and Pune University. Got commissioned in Department of Judge Advocate General of Indian Army, which is a judicial wing. He was enrolled in advocate in 1981 in the Bar Council of Maharashtra and Goa. During his service in Indian Army, Sir conducted numerous court-martial, including those of sensitive nature. Sir represented Indian Army in Supreme Court, Armed Force Tribunals, and various other high courts of India as well. Sir served in J&K, including Leh and Ladakh, northeastern states. He also took part in various military operations like Operation Rakshak, Operation Parakram, Operation Javelin, and Operation Orchid. Sir rendering distinguished, meritorious, and extraordinary services beyond the call of duty. Therefore, he was awarded thrice by His Excellence, the President of India, conferring him Ati Vishesh Seva Medal on 26 January 2017, Sena Medal on 27 January 2016, Vishesh Seva Medal on 27 January 2009. In addition, Sir was also awarded commendation once by the Chief of Army Staff on 15 August 2008 and thrice by the Army Commanders on 15 August 1994, 15 August 2011, and 15 August 2012 for rendering meritorious and outstanding service in the Indian Army. Later, Sir rose to the highest rank of Major General in the Department of Judge Advocate General and retired as a Judge Advocate General of Indian Army. Under his able leadership and guidance, Amity Law School is growing by the leaps and bounds. His visionary approach and outreach activities gives a new way to the unique thought process. With this, we profoundly invite you, sir, to give us a few words on this occasion. Please, sir.
Thank you, anchors. Am I audible to all of you?
Yes, sir.
First of all, I welcome Ms. Kriti and Mr. Prag, our guest speakers who have joined from Delhi. Kriti has worked as an associate in the media and entertainment team at Sagar Chandra and Associates in New Delhi, where her work focused primarily on copyright-related litigation, legal advisory, and contract vetting for clients such as media developers, music companies, etc. Prague, of course, is associated with Allahabad and Associate New Delhi and is integral part of the firm's intellectual property, technology, media and telecommunication, online gaming and data protection. Hence, both these guest speakers are expert in intellectual property rights. Now, coming to this topic is very apt. There are so many implications in granting IPR related issue to the music, because music, there are many actors in the music like singer, composer, record label, lyrics, etc. Now, how to give them copyright? How to distribute copyright? Of course, there is a copyright society which distributes these rights in equitable manner, but whether they are aware or not. For example, these days anybody can play music of someone. The concerned people who has composed this music and singer, etc., they are not even aware. And these people, they get all those monetary benefits like this. So these things are happening. To how to control these aspects where there is the IPR related issue, they come into fore. AI is getting into in worst scenario, because you use IA, artificial intelligence, to generate music, and how to give copyrights like copyright, etc., in such a scenario. These issues are of very, very important aspects, very important issues, which require a lot of deliberation and discussions. And I'm sure these two our guest speakers, Kriti and Prag, will enlighten you on these very complex issues. I don't want to say more on these aspects, and I request all the audience to pay attention to these speakers who have spent their time to speak to you all. Thank you and Jai Hind. Please carry on.
Thank you so much, sir, for your such a warm welcome. As we pass the mic to our experts, let's remember, knowledge shared is knowledge multiplied. Let me introduce our first speaker, Mr. Parag Singhal. Sir is associated with Alawat and Associates, New Delhi, and is an integral part of the firm's intellectual property, technology, media and telecommunications, online gaming, and data protection team. Sir handles various matters pertaining to IP laws and specializes in matters relating to trademark, copyright, domain names, designs, geographical indications, etc. He regularly advises domestic and international clients, ranging from individuals to multinational companies, as regards their IP protection, filings, and enforcement actions. Prior to joining Alawat and Associates, he was previously associated with DSK Legal and Luthra and Luthra Law Offices, India. Beyond his legal practice, Sir is actively involved in legal academia. He has previously served as a judge for national moot and client counseling competitions at various premier law schools across India, and has also delivered guest lectures and participated as a subject matter expert in certificate courses organized by leading institutions. Notably, Sir has been recently recognized as a recommended lawyer in the category of patent and trademark attorney in the Asia Pacific Rankings 2025 by Legal 500. Parag sir, I request you to kindly enlighten us with your knowledge and expertise. Please, sir.
Thank you, sir. Thank you, Priyanshi, for the warm welcome. So, I have also created a PPT here just to enlighten the students in a better manner. So, I'll just share the screen and so that we will again start the process. Can you guys see my screen right now?
Yes, sir. It is visible.
Great. So, as we celebrate the World IP Day on 26th of April 2025, the today's workshop topic is protecting musical works in evolving IP landscape. Because the theme is feel the beat of IP. So before going ahead with respect to the musical work in the IP landscape, I'll just briefly discuss in 5 minutes what is IP law and how to protect the copyright and what are the subject matters of copyright. So firstly, what is intellectual property? So as you are aware, I think because of the first lecture that has already been conducted yesterday, there are various facets of IP, which includes trademark, copyright, designs, GI, and even trade secrets as well sometimes. So the next topic is the purpose behind this workshop is copyright law. So the question comes into the mind, what is a copyright? So copyright is a bundle of rights and it is an essential aspect of IP protection, which simultaneously protects the rights of the creators as well as the authors. So if we talk even about the musical work, then also it protects the rights of the authors or lyricists or producers or composers, and it provides the exclusive rights, which also includes various rights like reproductive rights, assignment rights, and all. As you are all aware, I believe, because copyright is a bundle of rights, and you always get the copyright over the expression of idea. So basically, idea is not copyrightable. So if you think about anything in mind, doesn't mean you will get the copyright over the same. So idea is not copyrightable. However, the expression of ideas are copyrightable. When it comes to copyright, there are three things that should be taken care of. Firstly, as I mentioned, idea is not copyrightable. The expression of ideas are copyrightable. That means it must be in a fixed form or in a tangible medium to eligible for the copyright protection. That can be in writing, recording, or even in digital format. Secondly, you cannot claim right over the existing work that has been created earlier. So the work must be original in nature. So these are the two things that we should keep in mind as regards the copyright law. Now, regarding the exclusive rights, as I mentioned, it also provides the right to reproduce, distribute, perform, and assign their work. Now the topic is subject matter of copyright, works in which copyright subsists. So here I mentioned this flowchart, which specifically mentions the work that can be copyrighted. It includes literary work, musical work, dramatic work, choreographic work, even pictorial representations, photographs, music work, sound recordings, and even cinematographic films. So all these things can be covered under copyright, and people can get copyright over all these works. If we talk about the Copyright Act, then under Section 13 of the Copyright Act, it clearly talks about the work in which copyright subsists. So there are 3 points that I have mentioned here. In these work, you can take the copyright. The first one is literary work, dramatic work, musical work, artistic work. So you can keep in mind as LDMA. And then CS. C is cinematographic films, and the other one is sound recording. So these are the major areas and work where the copyright subsists. As regards the current workshop, since we have limited our discussion with respect to the musical work in IP, I'll just discuss what is a musical work. Musical work is defined under Section 2P of the Copyright Act. Musical work is primarily the composition that is primarily composed of music and can also include graphical notations. However, it doesn't include any words or performative elements that is intended to accompany the music. So when it comes to music, there are separate rights over lyrics, over the composed song, and even when the song is recorded. So the producer gets the rights over the recorded song. I'll also discuss that in a later PPT. So the question comes into the mind, what is the basic difference between the musical work and sound recording? So whenever you create any new song, there are two separate copyrights that you are creating. First one on the musical work because you have composed the music. So On that composition, you will get the copyright. And then the sound recording part, the recorded song, actual recorded performance. So on that as well, you will get the copyright. Now the basic distinction between the two is, as I mentioned, the musical work is the underlying composition of the song, while the recorded sound recording is the actual recorded version of the song. When it comes to musical work, it is usually created by the composer or sometimes even the lyricist. When it comes to sound recording, then it is always composed, it is always recorded by the producer. Here, this is the flowchart that I have just created for the reference, like who will be considered as the creator of the work and who will get the copyright over the works. So when it comes to literary work or dramatic work, such as like protecting the software, because software can also be protected in the form of literary work only, even the website UI UX designs and books and all these things come as a literary work. When it comes to the lyrics of the music, then also it will be protected under the literary work, and the author will be the creator of the work. When it comes to musical work, as the composer will compose the song, so composer will be the creator of the work. Similarly, for cinematographic film or even the sound recordings, producer will retain the right. When it comes to photograph, because photographer is going to use his skill, labor skill, judgment and others, then photographer will be considered as the creator of the work. Now the question comes, ownership of copyright in music. If we talk about section 17 of the Copyright Act, it clearly talks about the first owner of copyright. Under the copyright law, the concept of ownership is very different, because typically the author is the first owner of copyright. And however, it depends like who will be considered as first owner of the copyright, because while section 2D clause 1 says that in relation to literary and dramatic work, the person who writes these work will be considered as the author. However, when it comes to the songs, then the lyricist is the person who has first written the lyrics of the song. Then that person will be considered as or eligible to claim copyright over the lyrics of the song as a first author. Now, section 2D subclause 2 says that in relation to musical work, the composer would be considered as the author of the work, because here composer is the person who adds music to the lyrics of a song, and therefore he has the right to claim copyright over the music of the song. When it comes to the recorded song, as mentioned under section 2 UU of the Act, music producer is the one who undertakes the recording and broadcasting responsibilities and other technical leadership roles as well during the recording version of the song or even cinematographic films. In such a scenario, producer can also be considered as owner of the recording of the song. So it depends between mutually decided between the parties who will retain the copyright. Now, legal rights associated with creation of a song. So whenever any song is created, there are bundle of rights that are there. So who will retain what right? So I've just included this one example because copyright is a bundle of rights. If we take this example, supposedly if the Indian singer Darshan Rawal has like sings a song which has been penned by the lyricist Irshad Kamil, and its music has been composed by Pritam Chakravarti for a movie that has been produced by Imtiaz Ali. So in such a scenario, Darshan Rawal, who sang the song, is protected under section 38 as a performer. Earlier, the role of performer was not there, but post the Copyright Amendment Act of 2012, it has been added. And now even performers can also claim certain rights under section 38 of the Copyright Act. When it comes to lyricist, Irshad Kamil is also protected under section 1A of the Act, because his works fall under the category of literary work. The lyrics can be protected as in the form of literary work. Pritam Chakravarti, who is the composer, would be protected as the author of the musical work. Last one, in case, because there are certain instances when the song is composed by an employee of the employer or work for hire basis or commission basis. In such a scenario, the producer, like who has hired someone on the commission basis, will retain the copyright under section 17 of the Copyright Act. Because when we talk about Copyright Act and the protection of musical work, we should also discuss regarding the registration of musical work. Though in India, it is not mandatory to file a copyright application to get the copyright, because as soon as the work is created, you automatically get the copyright. In India, even there are some other countries that have also been a part of Berne Convention. And as per this convention, copyright protection is obtained automatically without the need for registration or other formalities. However, there are certain countries which have also placed a system to allow for voluntary registration. Voluntary registration is like the copyright registration, and by way of which you will get the statutory rights along with the common law rights, and it will help you during the disputes or during the ownership rights, claiming the ownership rights. When it comes to musical work, you have the right to file an application to protect the musical work, and the relevant form is form 14 that is there on the copyright online portal. However, when we file the application for any copyright related work, be it musical work, then in such a scenario you will have to mention certain details during the filing of a copyright application. This also includes the name of the applicant and the author. There are instances when the author and applicant will remain the same. However, there are situations when the applicant is someone else and the author is someone else. Then, in such a scenario, both the person's name or the entity's name will need to be mentioned specifically. Because in musical work, even the lyricist can retain the copyright. Sometimes, even the composer can get the copyright. Sometimes, even the producer gets the copyright. So, this is why it is mandatory in case of musical work to also furnish the relevant no objection certificates from the other authors, be it lyricist, composer, producer, or anyone else that is involved in the making of the song. So this is the copyright website, copyright.gov.in, wherein you can simply file form 14 that is there on the left side. And once you file the copyright application within 3-4 months, in case of clean application, you get the copyright registration. In the next slide, I have created this flow chart for the ready reference so that you will understand the whole copyright registration process when it comes to musical work or any other work. So when you file an application for the copyright, it is completely opposite when it comes to copyright as regards to trademarks. When it comes to trademarks, in such a scenario, you firstly file the application and the trademark registry examines the application. And once it is advertised, then the third party gets the opportunity to file the oppositions. However, when it comes to copyright, you firstly file the application and the application will be there in the mandatory waiting period, that is for 30 days. Within that 30 days period, any third party can come and file an objection letter before the copyright office. So third parties have the rights to file the copyright letters, objection letter within first 30 days. Subsequently, both the parties will get the intimation. Other party will also file its reply and the hearing will be scheduled. Subsequent to the hearing, the copyright office has the right to either accept the application or reject the application. Supposedly, if the application has been accepted, in such a scenario, the copyright office will now review the application and will see whether there is any technical error in the application. And if there is any technical error, then the copyright office can also issue the discrepancy letters. And within that 30 days period, you will have to rectify that discrepancy, and subsequently, the copyright will be granted. Again, even the registrar has the right to list the matter for hearing again. Accordingly, the copyright registration will be approved and you will get the copyright registration certificate along with the copy. So this is the complete whole process that is there. When we talk about the copyright application, in case there is no third party objection or any discrepancy raised by the copyright office, then within 3 to 4 months, you will get the copyright registration that will be valid. Once you file the copyright application, you also get the statutory rights, and there are some other bundle of rights that the copyright holders get. These are the rights, that is right to reproduce the work, right to prepare derivative works, even you have the right to display musical and artistic work, you have the right to give licenses, etc., etc. When it comes to the protection of copyright, then there is a term of copyright. Just for the ready reference, I have mentioned this term. It varies from countries to countries. In some countries, it is lifetime of the author plus 50 years. Sometimes it is lifetime of the author plus 70 years. When it comes to India, it is copyright here from the death of the author. So when it comes to literary work, musical work, artistic work, the copyright will be valid for the period of the lifetime of the author plus 60 years. However, when it comes to sound recordings or cinematographic films, because here you will get the copyright over the recorded song, so it will be counted from the date of publication. So copyright will last for 60 years from the date of publication. Now the question comes into the mind: is it possible to? We all know that we can take copyright. We can take copyright over musical work, and musical work is protected under copyright. However, do you think whether we can protect musical work under trademarks as well? So it is interesting to know that first trademark registration over a song title was produced for the song by this Kolavari D back in 2011, that is by Sony Music Entertainment India. So earlier people were only, like, even musicians were only filing applications for the copyright, but because, and even when it comes to trademark, then they were only protecting the title of the movie name, but they were not protecting the title of the song. But now musicians have, like, also started protecting the titles of the song, or even sometimes the famous lyrics of the song, so that no other person can replicate that song or even the famous lines of those songs. So if we talk about why this collaborative, it is already registered before the Trademark Office of India since 2011. Another example is of Taylor Swift's brand protection. So, as I mentioned, various musicians are familiar with copyright law. However, like, few musicians have mastered the art of building their own trademark portfolio, such as Taylor Swift. So, by January 2025, Taylor Swift owns almost 200 trademarks before the USPTO, which clearly shows her dedications to protect her songs, even her name, and even song titles and lyrics of their famous songs. Even Taylor Swift has now started filing applications in various other countries as well, and to secure registrations such as China, India, Brazil, Germany, Switzerland, etc. So by basis of this, Taylor Swift is able to protect, and even she's also enforcing their rights with respect to copyright and trademarks. I don't know whether you know or not, but this signature of Taylor Swift is also registered as a trademark. Now, another question comes into the picture. When we talk about copyright, then you can take copyright over the work. When it comes to trademarks, then you only can take trademarks over the products or services. However, when it comes to music, then there is no product or service involved. Then how can you take trademark in a respective class? So what happens in such a scenario? They mostly file an application for trademark under class 41, that is there for entertainment services, and accordingly they secure their rights. And sometimes they also release some goods such as stationery or merchandise with their name or other things, and basis the same they file their applications under class 16 or class 25. Now the famous part come licensing of copyright, because it is an important part, because people are just playing songs everywhere. So licensing of copyright in musical work, we will first discuss the basics of licensing, though I believe it has already been covered earlier, but still, licensing is when the owner of the copyright, who is the copyright holder, grants a license with respect to the work to any third party to use the work. But during the licensing part, they do not transfer the ownership aspect. So the licensing can be classified under the various aspect. When we talk about voluntary license, that is there under section 30, the owner of the copyright in a work may grant any interest in his copyright to any person while license in writing, which has to be signed by him or herself or by the duly authorized agent. Now, when it comes to voluntary license, it is not mandatory to just create the voluntary license in the existing work. It is also allowed to create voluntary license in the future work. When it comes to future work, it will also be valid and come into force when such future work comes into existence, unless that voluntary license will not be applicable. When it comes to compulsory license, there has been instances when the copyright holder copyright holders are not providing licenses to third parties. In such a scenario, India, being a member of Verne Convention, has incorporated this provision under the Copyright Act. Under the compulsory license, the court or the government can directly provide compulsory license in the public interest, but it is only provided when the work is withheld from public. As regards the musical work, when we talk about licensing, there is also concept of statutory license for cover versions of song, because you actually see that there are so many songs are coming up with the, like Sanam Puri, like he's making all the cover versions of song. So it is also like now have been included under section 31 clause C of the act, which clearly says that when anyone is making a cover version of any song, he or she is required to give notice to the original copyright holder. So that is the first requirement. Whenever you make any cover version, you will have to give the notice to the original copyright holder. The second thing is you will also have to provide the copies of all cover versions or labels with which the cover songs recordings are to be sold in order to safeguard the interest of the original copyright holder. So these are the two primary requirements. Apart from this, whenever you make any cover version of the song, you will have to specifically mention that this is the cover version along with the title of the song. So these are the things. Apart from this, certainly you will, the provision also provides for royalties to be paid, because you are using the original work of the copyright holder, then certainly you will have to provide some sort of royalties to the copyright holder. So in the case of Gramophone Company of India versus Super Cassette, in this case, Delhi High Court held that mere fact that the plaintiff refused to accept the royalties is more than enough to establish that they had no intention to allow the defendant to make the cover version of the song. So in this scenario, what happened? The party like simply asked for the person copyright holder that he or she will give the royalty to the original copyright holder, but they want to make the cover version of the song. Since they clearly refused, the copyright holder said that I don't want that my song should come as a cover version. So it is clear that defendant has refused the rights. Defendant clearly said that they are not allowing it to make a cover version, and still if the party is making cover version of the song, that will be considered as copyright infringement. There is another case of Saregama India Limited versus Sky Bangla Private Limited. In this case, the Calcutta High Court also referred to the provision of Section 31 Clause C of the Act and held that the defendants have neither taken any consent of the plaintiff nor provided any statutory license, which are the primary prerequisite of any copyright license, which clearly pose a prima facie case of copyright infringement. Now, when we talk about licensing aspect, then the role of copyright societies come into the picture. Even the copyright societies are mentioned under Section 33, which clearly says that copyright societies must be registered under the relevant act, under the relevant section of the act, and they have authority to issue licenses. Subsequently, along with the issuance of licenses, they also have the right to collect royalties from the users who are using the song or the author's work and allocate the same to the relevant copyright holder. Because there are so many songs in the market and there are so many copyright holders, supposedly if I just want to play 8 songs in my cafe or somewhere else in commercial establishment, it is impossible for me to reach out to each of the copyright holder and then take separate licenses from each of them by way of paying the royalty. In such a scenario, it is always better and that I'll just connect with the copyright society and will take the copyright license over all the 8 songs in one go. So this is why the role of copyright society is very important. Now, there are certain copyright societies that are already registered in India. One of them is IPRS, that is Indian Performing Rights Society, which is a union of artists, singers, composers, and producers of copyrighted music. So all of these uh, people are there, and on their behalf, IPRS collects royalties and then distributes it among its members. Now, there were some other copyright societies also that were existing earlier, such as PPL, Phonographic Performance Limited, which actually owns 400 music labels and 45 plus lakhs sound recordings, including the recordings created by Sony Music, T Series, etc. And they used to grant licenses to commercial establishments like cafes, bars, clubs, etc. until March 2025. So this is very recent. But on 15th of April 2025, the High Court in this case has clearly held. So I'll just go with the basics of this case. In this case, PPL sent a cease and desist notice to Azure to simply comply with the licensing aspect, or otherwise do not play the song. However, Azure did not comply with the requirement. Subsequently, PPL filed a suit before seeking a degree of permanent injunction to restrain Azure from exploiting or using the copyrighted work without the licensing. So in such a scenario, the single judge of the High Court clearly issued an ex parte ad interim order and restrained Azure from exploiting PPL's copyrighted work. Subsequently, Azure filed an application for vacation of stay and removal of this order. However, the same was refused. Thereafter, Azure filed an appeal before the divisional bench of the Delhi High Court, arguing that PPL cannot grant licenses without being a registered copyright society under Section 33(1) of the Act, which is the mandatory requirement. Because only the copyright registered societies have the power to provide licenses when it comes to any musical work. Now, the court ruled that in favor of Azure, holding that PPL was previously registered from the year 1996 till the year 2014. However, subsequent to the amendment of 2012 Copyright Amendment Act, there were certain other instances that had been included, so that each of the parties were supposed to take the fresh copyright license as a copyright registered society. So PPL's application was also filed. However, the same was rejected. As a result, PPL is currently not a registered copyright society and cannot issue licenses for the sound recordings assigned to it. So finally, the court also emphasized that PPL, for granting the licenses, PPL should be either a registered society or a member of one. However, since PPL is not even a registered society or not even a member of any other copyrighted society, then in such a scenario, they do not have any right to grant the license over these songs. As you know, there is so much infringement of musical work, so I thought I'll just include this aspect as well in the presentation. And I've just covered the basic, like when we talk about the infringement of musical work, it is primarily being infringed on social media platforms such as Instagram or YouTube. So what do you think if we talk about, like, if we just take 20-30 second videos from the original work, does this amount to infringement of copyright? The answer is big yes, because any use of a copyright work, section 51 clearly says any use of a copyrighted work without the owner's consent constitutes infringement. So no user can infringe the public performance rights of a copyright owner by using the work without their permission. Now, I believe you have seen that sometimes people just give the credits to the original copyright holder, thinking that because they have given the credits, so no such copyright will be infringed. However, even if you give the copyright credit to the original creator while posting or uploading the song, doesn't mean that you will is not infringe. You are not infringing the copyright. You will still be liable for infringement. In order to remove copyright infringement claims, social media platforms have also come up with certain other guidelines and measures, such as content filtering mechanism, when they are filtering the contents in every 15 days and they are just removing the infringing contents. Even when you talk about Facebook and Instagram, they also have their copyright and trademark takedown protocols. So there is a specific section on Instagram and trademark, even on YouTube, when you can simply file takedown request when it comes to the infringement of copyright or trademark. So these are the measures that these social media platforms are taking. Even sometimes social media platforms have also created their own copyright policies over the musical content. Even when it comes to the, like, when there is a filing of a case, when even the social media platforms have been made a party, they simply say that we are the intermediaries and we do not have any role as such, because we are just uploading the content that has been created by someone else. So we are just intermediaries and we are not liable under the IT Act. So they take the benefit of defense of safe harbor provision under section 79 of the act. So this is also there, but because courts have previously given the instructions to all the social media platforms to robust their policies. So for example, Instagram terms of use and community guidelines clearly state that no user can post content that violates someone else's IP rights, including musical work and sound recordings. Even Instagram has come up with a new feature wherein they have created a music library and have accumulated various copyrighted works through agreements or licenses. In such a scenario, what they are doing, they are just not providing any money to the person who has uploaded that video over the views. However, they are retaining the views, they are retaining the money, and subsequently they are transferring that in the form of royalties to the original copyright holders. There was another case of Bharat Jodo Yatra when even INC was also faced same issue, copyright infringement issue, because they were also using the sound recordings for the film KGF Chapter 2 in their political rallies. Here, the copyright owner MRT Music alleged that their works were used in 30-second videos shared on social media platforms without any agreement. So the Karnataka High Court clearly held that it is a prima facie case of infringement and condemned the party for claiming IP rights over the content that has been created by someone else and they have not even taken the prior permission or license from that person. So this topic is very relevant. Music played in clubs and weddings, whether it is legal or illegal. So when it comes to clubs, because this is a commercial establishment, as per the act, it clearly says that if any pre-recorded song or music is being used for commercial purposes in a public space, then it attracts the liability for copyright infringement. And in order to avoid such liability for infringement of copyright, it is always advisable to take a license, that is the public performance license, for using any copyrighted song. So it is for this purpose copyright societies comes into the picture and they provide the license for all the clubs and all. There is this case of Range Road Music versus East Coast Foods. In this case, there were several music companies who sued a restaurant for copyright infringement for playing their songs. Earlier, the restaurant refused an offer of license and said that they are not playing any songs as such. However, when through the personal investigation, these copyright owners got to know that there were some 8 songs that were being performed at the restaurant. As a result, a suit was filed wherein the court found that the restaurant guilty, leading to paying damages and even the music company's attorney's fees for filing the legal action or suit before the court. Last part of this lecture is weddings. When we play music in weddings because that is not for the commercial purpose, does this amount the copyright infringement or not? Though the Copyright Act clearly exempts playing copyrighted music in non-commercial settings, such as weddings, under the umbrella of copyright infringement, however, the copyright societies always kept asking license fees for the copyrighted songs that are being played in weddings. So that was a very relevant issue because there was no clarity on this. So this issue has recently been clarified by the DPIIT by issuing a public notice. In the public notice, they clearly pointed out towards Section 52(1)(ZA) of the Act, which states that use of copyrighted songs in any religious ceremonies, such as functions that are being held in temples or even in the form of marriages and other functions associated with marriages, will not amount to the infringement of copyright. That's it, guys. In case you guys have any questions, then we can sum up the questions within the next 5 minutes.
If any of the participants have any questions, they can ask to sir.
There is a question: what is the difference between phonogram and music and sound recordings? As I mentioned, there are separate rights that are there for each of these things. When it comes to music, then it includes the composition of a song. So in that scenario, all the background music, underlying work, for that matter, composer can get the copyright. However, as regards the sound recording, includes all the aspects like lyrics, background song, underlying work, and even the recorded song. So in such a scenario, the person or the producer who has actually recorded the song will get the copyright over the sound recording.
So we have received a question from a student. Can you explain the case of hotel orders in Goa for playing songs in wedding?
As I mentioned, if we talk about hotels, then if it is for commercial establishments and cafes, then they will have to mandatorily take the licenses. However, when it comes to weddings, then there is no such license. Though copyright societies still sends legal notices sometimes. However, this has been regularly clarified by the DPIIT that the songs are being played for religious ceremonies such as weddings under section 52 clause 1 clause ZA of the act, and under this the parties are not required to take any such licenses. Still copyright societies doesn't understand and they always ask for licenses. So this is a very niche issue which is not still not clarified yet. Sometimes they give licenses, sometimes even parties also take licenses, sometimes they do not take licenses.
All right, sir. We have another question for you. Can you explain the overlap of copyright and design in the light of recent case?
It's a very long issue, so like it will take another session for this. However, in summary, there is a recent Supreme Court case that has been recently held. So supposedly, you have taken a copyright, though this is not related to musical work. So in case you have taken the copyright over any artwork, which also includes certain industrial aspects. So copyright is protected in the form of artwork. However, as regards the industrial products, which has some forms of industries aspect. In case you use that copyrighted work for more than 50 times, then the copyright will cease to exist. In that a scenario, you can only retain the rights over the design work and not on the copyright work. So this is the answer.
All right. Thank you so much, sir, for your expertise.
Thank you.
Sharing your
In case
knowledge
you
with us.
guys have any other questions, then please feel free to reach out to me on LinkedIn, or otherwise you can also ask Shubhangi and she can direct the questions to me so that I'll be able to answer the questions. Thank you guys for the lecture and for inviting me today.
Thank you so much, Parag sir. It was really great to have you. And I am really much sure that the students would have gained a lot of insights in regards to the registration process, in regards to the cases. They got a new insight that wherein there is a link of the trademark in music also. All these
Yes.
brand which has been which are being created.
Yeah, I thought like it's a recent topic and like not everyone knows about the
Yes, right.
trademarks in music, so I thought I should include this part.
This was really very interesting. I think these students would have really enjoyed this session. And in future also, we are looking forward to have more such interactive sessions.
Certainly, I will always be there. Thank you, Shubhangi. Thank you, everyone.
Thank you.
Thank you.
With this, I would like to introduce the second speaker for the day, Ms. Kriti Ramadamu. Every idea begins with imagination and with IP. We give that imagination the power to shape the world. Ma'am has worked as an associate in the media and entertainment team at Sagar Chandra and Associate, New Delhi, where her work focused primarily on copyright related litigation, legal advisory, and contract vetting for clients such as media conglomerates, music companies, and radio broadcasters. Ma'am has also dealt with the telecom compliance matters involving the Ministry of Information, Broadcasting, and regularly engaging with clients of local councils across various jurisdictions. During her time in practice, she has worked closely with the firm's partner, including independently briefing them on the key matters and assisting on the project related to International Trademark Association. Ma'am is also an alumni of Amity University, Kolkata. Thereafter, Ma'am completed her LLM in intellectual property rights from Hidayatullah National Law University, Raipur, where she ranked third in her class and worked as a teaching assistant. During her postgrad, she presented a paper on statutory licensing at Rajiv Gandhi School of Intellectual Property Law, IIT Kharagpur, and secured second place. Ma'am continued to explore her interest in academics by delivering lectures at Indian Institutes of Art and Design, New Delhi, on the occasion of Fashion and IP. I request you, ma'am, to share her knowledge and expertise with us. Over to you, ma'am.
you. First of all, thank you to Amity University Gwalior and the student conveners for the wonderful introduction. And thank you for Ms. Shubhangi for organizing this event. I think it's very important for us to know about the intersection of IP and music, especially at this given point of time that we're living in, where everything is changing so fast, whether it's about listening to music on Spotify or uploading reels, and this current situation that we are in terms of artificial intelligence and the rights that we hold. So I'm very happy and I'm looking forward for you to truly understand the lecture. So in order to understand what exactly the role of intellectual property is in terms of music, I think we have to see that what music is specifically. So music for in the common language can mean a lot of things. It can mean the videos that you see on MTV, VH1, or YouTube. It could also be just the sound of a sitar. Sometimes it could also be the music that you hear on the radio. So this is what different people interpret music as. But the Copyright Act, as Mr. Parag Singhal had earlier said, does not confuse all these definitions with each other. It specifically lays down what musical work is. It lays down what sound recording is, and it says what cinematograph films are. So when you see a video on YouTube, it comes under the jurisdiction of cinematograph film. Although it does not just mean an entire body of film, it could also mean a piece of the film, which could be a music video, or what we also call audiovisual works. Then what we have is sound recording. It's basically, it could again be the sound of a tabla, it could be sound of a sitar, or it could also be the entirety of the music, including the lyrics, the musical works that has been brought together by way of a sound recording. Then you also have, lastly, the musical work, which is the underlying composition, the underlying lyrics that's there in every music that we hear right now. So these are the three categories of musical works, sound recordings, and audiovisual works when you hear the term music. Now, when you think of law and music, the first thing that comes to you is copyright. There's no relation of patent with music. There's very little relation of trademark, although as Mr. Singhal has said, these days you trademark the title of the song, of the movie, but that's pretty much there is to it. And obviously GI and other trade secrets, semiconductors, all these aspects of intellectual property do not matter when you talk about music and intellectual property. So let's understand what copyright is. Copyright is a right which you behold whenever you create a literary work, a dramatic work, a musical work, a dramatic work, or a cinematograph film. So these are the categories in which you have control over what you want to do, whether you want to adapt it, whether you want to make it into some sort of dramatic drama or anything like that. So this copyright is vested in you the moment you create it. It's not something such as trademark or patent where you have to go and you register it. Although a lot of people tell you that you should be registering it, it's only for legal purposes. It's only for big companies that you need something which is solid, which allows you to prove that you have made something at a given particular time. But for us common people, there is no need to register a copyright. It comes into you, the right is vested in you the moment you create it. Now, this right stays with you from the exact language is a bit complicated. So it stays with you till your life, plus 60 years of the next beginning of the year. So, for example, if I am living here, if I am on this earth for, let's say, 50 years, so 50 till from now to 50 years, I have the right. And then I'll have the right from the next year, 60 years following the 1st of January of the next year, from my date of departure from this earth. So this is the case for musical work, and for cinematograph films and for sound recordings. The 60-year is changing. So no, 60-year is there, but the right starts from the date of publication. So it's date of publication plus 60 years. Now, for a musical work or for any sound recording, anything to have copyright, it needs to be original and it has to be an expression of the work. It cannot be, and what I mean by expression of the work is that it cannot be an idea. It cannot be something that you have in mind. It has to be written somewhere. And even if it is written somewhere, it's not something which is a theme, you know. For example, there are a lot of movies that have superheroes, right? But for example, if Marvel, hypothetically speaking, is the first movie, that the first production house that has come up, let's say with Superman, that does not bar other people to come up with, let's say DC to come up with Batman, right? It's just a theme. It's just an idea of superhero. It's just an idea of good conquering the evil. And many movies thereafter have come out, have utilized this idea to make movies, right? This is what I mean by expression. And there is a dichotomy, there's a very thin line between idea and expression. So the moment your work is an expression of something, it becomes a copyright. I mean, it can be a copyright. And then what I mean by original is that it has to have some flavor of creativity. I mean, you could write, let's say, a two-liner poem. It could still be you can still have copyright over it, because what you've written, you've thought and you've written it. It doesn't matter that you have to be Picasso or some level of genius to have copyright over something. You don't have to be Pandit Ravi Shankar to play sitar, to compose the kind of music that he has. You don't have to be Farhan Akhtar to sing. At the moment you compose something, the moment you do something about it, you automatically have rights to it. And as long as it's creative, as long as it's not something mechanical, it's not 2 plus 2 equals to 4, you have rights over it. You can also have copyright when you have exerted a certain limit of skill, labor, and judgment into it. For example, you see a lot of blogs where they basically analyze judgments that have recently come up. Manupatra does it. It sometimes it analyzes, sometimes it simply presents the judgment in a format which is similar but not exactly the same which has come out. So although it's just words which has been written by the judges, the way they present it, the way they say that this is conquering, this is dissenting, this is the analysis, this is the fact, the way they present it, that also has, they also have copyright over it. So this is what copyright is in a technical term, and how you need originality and expression to have copyright. Now, when you, for example, let's take a musical work, right? So suppose Pritam Chakraborty, he composes some music, he becomes the author of the composition, right? And if Farhan Akhtar sings it, he becomes the artist, he becomes the singer, he becomes a performer of that song. And if Javed Akhtar writes it, he is the lyricist of the song, right? So all of these people are authors, and they are the first owners, what we call, they are the first owners of the work that they have created. Now, if there's a producer, because what happens is in India, there's there's a very big domination that has been created by Bollywood, right? So there are very few artists that produce music independently, or what we call indie songs, right? There are very few bands. Most of the songs that have been created are because there's a movie, and then the movie has to have a song in it, and then automatically the producer of the movie is the owner, right? So the owner and the composer and the lyricist, they form an agreement where the owner says, you make these songs for me, and then you give me the rights to those songs, and I'll pay you a sum of it, right? Now that sum can also be like a lump sum, and that can also be a royalty which has been given um, throughout the year, throughout the term of the copyright, but in certain intervals, right? A lot of times the producers do not follow this. They just give you a lump sum and then you're done with it. But the Copyright Act says that royalty is inalienable right, which has been given to you, and you have the right to collect it at proper intervals. Now, this is a very big issue in the media industry where the person who is in power sort of dominates over you, does not give you a place to bargain, and takes over all the royalties by giving you just a lump sum. Now, what happens is that this producer who takes the rights forbids you from being the first owner. In the contract itself, they state that because this is a contract that you have entered, because you have done this thing for me, whether it's in a state of employment, whether it's in a state of commission work, I hereafter become the first owner, and you are not the first owner anymore. You are just the author. I'm the first owner, and I will have all the rights, and you will have no rights. This is a sad reality, but this is exactly what happens. And there have been various litigations that are there, which are still pending, and which may possibly go to court in terms of this. Now that you've known what an author and an owner is, there's a very important term which you have to be familiar with, which is licensing and assignment. So, as you may already know, licensing is basically when you give the other party, the licensee, an interest in your work, right? So, if I give you the license to use, let's say, Chelea or something like that, Chaya Chaya, let's say, okay. If I let you use the song Chaya Chaya, then you can only use it for the amount of years, fixed amount of years that I have given you the license for. You do not own it. But in terms of assignment, there is a proper vesting of right. There's a proper transfer of right which has been given, and the assignee becomes the owner of the song, right? Now, this assignment can also be for just a year. You become an owner just for a year, or maybe if there's a full body of works, let's say there is like an album and there are like 3, 4 songs, I can only make you the owner of, I can only transfer the rights to you for, let's say, the first 3 songs. So, this can also be called part ownership, part transfer, part assignment of the entirety, the whole of uh, the entire body of the album has been given to you, just whole assignment, right? Similarly, for licensing, this is also the case. You can either license only just a few songs or part, or you can license the entire thing. Now something which is very important is that both licensing and assignment has to be in writing. In no way is any sort of you can't just give it to somebody by orally saying it, right? Now let's try to understand what exactly. Now see that now when you create a music, when you hear a music, there's several players in that, right? So there's obviously your author, there's your owner. Now there's also something called a copyright society or a collective management organization. These copyright societies can be for a number of works. They could be there for musical works, they can be there for sound recordings, they can be there for screenwriters even. You know, when you watch a movie, there are certain, I mean, the movie obviously has a script, right? So the person who actually writes the script, or when you watch a episode, the person who writes that episode, they also have a certain copyright, but we will not get into that. For now, let's focus on copyright societies of musical works and of sound recordings. Now, for copyright societies of musical work, the biggest CMO, which is Collective Management Organization, is IPRS, Indian Performing Rights Society. Now, they are a company that deal with licensing of uh, musical works of the members who are there in that society to other people, right? So, for example, if I am a songwriter, a lyricist, or a composer, and there is a copyright society which is IPRS, I will assign my work to IPRS, and then they will have the rights to give my work, distribute my work to different people, right? They can give my work. There's a cafe that needs my work, they will distribute it to them. If there's several, like if there's a event that's happening, on ground event, if there's a cricket match or something like that, my work has been utilized by those in those events through IPRS. They do not directly come to me. Of course, I also sort of have the right to assign to license those works individually in my individual capacity. Now, similarly, you also have corporate societies for sound recordings. Now, there are several corporate societies for that. The biggest is RMPL. Now, RMPL basically is a registered corporate society for sound recordings, but apart from that, you also have Novex, you also have PPL, who are not registered corporate society. PPL used to be at one point of time used to be a registered corporate society for sound recordings, but it is no longer a corporate society. You also have, yeah, so there's RMPL, Novex, and there's PPL, who all deal with sound recordings. The only difference is that for Novex and PPL, they are in the business of dealing with distributing and licensing these sound recordings, not as a corporate society, but as an owner. So all these people who own sound recordings, they assign their work to PPL, to Novex, saying that you deal with my songs. And then by virtue of that assignment, PPL, Novex, they further license the songs to other entities, right? There was a recent judgment where the Delhi High Court, two-judge bench of the Delhi High Court had said that PPL cannot license songs anymore. It has to be a member of RMPL in order to license the songs to different entities. And it also told other entities, events, other cafes, whatever, to pay PPL as per the rates of RMPL. Now, this was an issue because it does not make sense when PPL already has a rate chart of all the. So basically, the rate chart is not just for one particular song. It's for the entire library of songs that they have, right? So they have different rates for songs to be utilized in commercial establishment, different rate for songs which have to be used in a on ground event such as a cricket match or a concert, right? So there are different rates for that. So why should PPL, despite having its own commercial freedom to have its own rate chart, follow RMPL's rate chart, right? So this went up to the Supreme Court, and the Supreme Court only stayed the two-judge bench judgment of the Delhi High Court, only stayed it with the aspect of this payment. It did not stay the paragraph where it said that PPL has to be a member of RMPL. It only stayed the aspect of PPL being paid rates as per the RMPL rate chart, right? So this is again something which is ongoing. We don't know when the actual judgment will come out, but because this was an SLP, right? So, and they have just granted leave to leave to argue the SLP. They haven't exactly given a final judgment on this. So this is what has been happening right now, and why it's so important to have a corporate society, because it's like a bridge between the user and the owners to license the work. Now, apart from all these things, what happens? How do you exactly infringe a copyright? Right. So if you use my music without my permission or authority, without it being in writing, you automatically infringe my copyright. So this provision of infringement is under Section 51 of the Copyright Act. Furthermore, Section 52 talks about fair use or fair dealing. It says what does not amount to copyright infringement, and we'll get to this a bit later. Now let's try to understand infringement a bit more, right? So once you see that a person has infringed your copyright, what do? You don't just sue them directly, you send them a legal notice. You try to understand what happened and you tell them that you cannot, you have to cease and desist from using my copyright. And then if they don't agree, then you tell them that we will be taking legal action, and then you file a suit, it comes before court. Now who can sue? The owner can sue it, the exclusive licensee can sue it, or anyone on their behalf can sue, right? So even corporate societies such as IPRS or PPL, even they can sue on behalf of their of the actual owners of the copyright. Now, what happens exactly when you? What is the result of? What is the relief of this copyright infringement? You can pay for an injunction, temporary or permanent injunction, where you tell them where the court tells you, the infringer, the defendant, that you cannot use the song or the sound recording or the musical work or whatever ever. Sometimes they give you a time, sometimes they tell you it's a permanent injunction, so you cannot use it any further. You can also pay for damages. You say that this is what loss, what you've done to me, basically has caused a lot of damage in my business. So you pay a particular sum, right? And you can also ask the infringer to provide accounts of profit. Basically, which means that whatever profit you have received during your use of my work, in illegal use of my work, you give all that profit to me, right? So these are the three things that happens, what you can pay for. Now, where do you institute this suit? The first place you institute this suit is a district court. And in case you don't want to file it in the district court, you could file it in the high court, provided that the nature of your suit, the pecuniary jurisdiction of the high court is satisfied. For example, in Delhi High Court, it's 2 crores. Now, again, if the district court already has given a judgment or has given some order and you want to appeal against that, then you can again file an appeal before the before the Delhi High Court. In extraordinary cases, cases which is very urgent in nature, which you can also file SLP before the Supreme Court. So this is the technicality of the filing of suit, and after this, let's come to fair dealing. So what does not amount to copyright infringement? So this is provided under Section 52 of the Copyright Act. In India, we call fair dealing. In outside India, I suppose in US, they call fair use, where if you use the work for research purposes, news reporting, or any sort of personal use, where you do not generate any income, or if it's not for commercial use, right? It can be termed as fair use. Now, what exactly fair use is really it's already given there under section 52, and anything beyond what's been provided under section 52, which has like, I think it has clauses till ZA, which is, I think it has clauses till ZD or something like that. There was like a lot of restricted amount of work, which only those works, if you only do those works, amounts to fair use. You are saved from copyright infringement. Anything above that and beyond that, you will be infringing the copyright. Now, why is fair use such an important topic to discuss? It's because, for example, if you use something for 3 seconds, right? If you use something for 3 seconds, and if those 3 seconds are something very integral to the music, to the sound recording, if that is what distinguishes it from other music, then those three seconds can amount to copyright infringement. But if those 3 seconds are just random pieces of music, it's not the hooks hook part of the song, right? It's just some random song, some random composition that you've taken up from one song, then that can also be that is a fair use. Because this is the principle of de minimis, where if you use something, even if it is copyrighted, um, and somebody else holds the copyright to it, even if you use it for like 3 seconds, very little time, then you are saved by the principle of de minimis of fair use, and you will not be, you cannot be sued for copyright infringement, right? But if the 3 seconds that you've used is something which is very crucial to the body of work in that copyright, then there is a very big chance that you might be sued under copyright. Now, another reason why fair use is so important is because of the generative artificial intelligence that we have right now. Because all these AI companies, they say that this is fair use. What I'm doing is fair use. This is just for the purposes of making the AI learn certain things. I am not generating anything. It completely comes under the field of research work. So it's not infringing at all, right? There have been multiple suits that have been filed, multiple things that you see in the news. The latest is Studio Ghibli, the Ghiblification uh, a, of different photos of anything. The moment you tell ChatGPT, you convert this into a Ghibli movie, it makes it like that, right? So Studio Ghibli never gave rights to ChatGPT to uh, teach their machine learning software to actually understand what exactly to understand and see and to generate works which are similar to ChatGPT. It has to license its work. Anybody should be licensing its work to ChatGPT. ChatGPT should be using that license and then only generating certain things, right? Else you can just pick up anything from the internet and generate it, which is unfair, and it leads to a lot of loss to all the companies. So another part of infringement which I would like to say is, how do you know something has been infringed, right? Specifically in terms of music. So there's a test which is called a lay hearer or totality of impression test. And if you compare two things, right? So there was this song by Ram Sampath, and after that he composed that song, and he saw that there was another song by Takesh Roshan which he used as I think it was Crazy 4. So he saw that these two songs are very common, and then he filed a suit against Takesh Roshan, and this went up to court, and the court said that there is a substantial similarity between these two songs, and which is why it's a copyright, right? And again, how much of that song have you, how much of the original work have you used? First of all, it has to be similar. And second of all, the amount of usage of the original work has to be quite considerable for it to become a copyright infringement. Um, again, coming back to AI, there are several suits which have been filed in India itself. There is something, there's a suit which is filed by ANI versus OpenAI, and several music companies such as Sony, TCD, Saregama, they have filed an intervention. So they also want to be part of that suit to see the outcome of the suit. Because obviously, if you tell ChatGPT, you know, or any other any AI software for that matter of fact, you tell them that sing a song like this is the song. Can you convert the song in the voice of Sonu Nigam, or can you make a song sound like something by Sachin Jigar, right? So they have a very particular way of expertise, very distinctive sounds, and if you use their work and generate the content accordingly without any license, then you are indirectly are sort of infringing the work, right? So that's about it. What my lecture today entails. And if you want to know more about it, then I will be happy to answer some questions.
If any participant has any question, they can ask to ma'am. Ma'am, we received a question from one participant. Can you explain the use of AI in music and ownership issues?
Okay, so the thing is that when you give a prompt to ChatGPT, let's say, uh, and the ChatGPT generates something based on no prompt, then who is the owner? Who is the author, first of all? Who is the author of that work which has been generated? And thereafter, who becomes the owner, right? So this has been a topic of debate, and it has not yet been demystified. There's no certain judgment on it, so it's very hard to say exactly who becomes the owner, because several different jurisdictions, in UK, for example, they in a way interpret by the definition of author, they allow computer or machine made objects to be authors. But our Indian Copyright Act, specifically the way it's been written, it does not allow anything else apart from a natural human being or any other company, for that matter of fact, not just a natural human being, as long as it fits the description of what a person is. It does not allow anybody else, not even a computer, to be a author of what has been prompted, right? So whatever result comes out of ChatGPT, for now in India, the ChatGPT is not the owner or the author for it, unless some other jurisdiction says otherwise. But it has not been clarified yet.
Ma'am, another question we have received is, if innovative technology is used in creating music, then patent law is also involved in copyright. Can you clarify on this point?
Sorry,
Ma'am,
yeah,
you are-
I don't think patent law can be involved in this, because you grant patent in a very restrictive sense. It has been granted as per Section 3 of the Patent Act, I believe, and none of them, it does not fit the, I mean, you can't grant patent to a music, right? It does not come within this definition of what can be granted to a patent. So I don't think a music can be granted patent at all, if that's what the question is.
All right. Thank you so much. With this, we profoundly invite our faculty coordinator, Ms. Shubhangi Gupta, Assistant Professor, Amity Law School, AUMP, for the vote of thanks. Over to you, ma'am.
Thank you, Priyanshi. Thank you so much, Kriti ma'am. It was really, great to have you. And it was really a very profound session wherein you discussed the insights and the use of AI in the music industry. because this is a topic which is much, talked about, and often it leads to confusion among the students. So I really hope that with your profound knowledge and the insights which you gave on the use of AI in music industry, and also with the case laws, the basics of music in copyright, the students would have gained a lot of knowledge in this regards. And it was really great to listen to you and hear your views on this particular theme which was released by WIPO. So really looking forward for more such insightful sessions and to be organized, and looking forward for the same. Thank you so much for accepting
so
our
much.
invite
Thank you
and
so much.
delivering the lecture. Thank you.
Looking forward to more such sessions, right?
Thank you. Yes, Priyanshi, we can end the session now.
With this, we have come to the end of this workshop. May the ideas shared today find their way into innovations tomorrow. Thank you so much for all joining us. We can leave the meeting now.
Can we close, ma'am?
Yes, sir.